All right. Hello, we're Armstrong, your real estate agent and advocate. We are going to get into court. We are still in Michigan, but we're going to check out a different judge's courtroom, Judge Simpson. And we're going to just see what's happening in their landlord court, landlord tenant court. So if you haven't done it already, let's take care of some business. Just a little business is all free, nothing, no big deal. I don't want your money. Just like, share, and subscribe. Keep your money in your pockets. It's a recession. I don't need the money. Just go ahead, like, share, and subscribe. Let the YouTube world know that we are here. We're doing YouTube-y things. And it just helps the algorithm help more people learn more things relative to real estate. As you know, I am your realtist, okay? If you need a representative throughout this nation, call me. I can refer you to the right one, baby. All right. Here we go. And this is Judge Kirsten Simmons court, okay? So I believe this is the right one. Just gonna press play. We're gonna see. Yeah, here we are. This is the right one. Make sure you can hear. It's kind of quiet right now. Everyone's getting situated. I don't like her mic. You probably don't like my mic, but we're gonna do things as loud as we possibly can because we keep it up here so that you can hear. So take those things out your ears or turn it down because we're going to be loud.
Yes, Teresa Donovan.
Okay. You cannot proceed via telephone for a court proceeding in my courtroom.
First time I heard this, I didn't understand. It's like, what? We're doing Zoom. But it becomes clear a little later. She's just saying you can't be on the phone. So if there are, most of us download the app onto our phone. We use the app on our phone. That's okay. That's not what she's talking about. She's talking about people who are dialing in via phone. It's not a telephone conference appearance. And typically those are only reserved for attorneys anyway. So, because if you have to testify, you need to be visual to the court. They need to be able to see you raise your right hand and, take your oath. They need to ensure that you're not being coached by someone else. Make sure your surroundings are good. But listening to this lady on the phone, I'm wondering if her state of she's all right.
Okay.
She all right? Is it all right?
You cannot carry on a court proceeding via telephone access only in my courtroom. You need to have video or you have to come in person.
All right, we're room deep.
Sure,
54A.
Look, I'm having difficulties, Your Honor.
I'm sorry, I couldn't hear you.
Okay. I didn't want to miss my appointment.
That's good. That's really good. She's saying, I wanted to abide by the hearing date. I did not want to be in contempt or have a failure to appear. I don't want to disrespect the court. It's great, but you have to actually appear, and there's two choices by which of doing that, and it's not by telephone. Okay, that's not the option. Can't call in.
Okay, so I can show up in person?
Yes.
Yeah, but it has to be today.
The courts are open. Judge Brian tells it all that. The courts are open
what
to
time
you.
Works?
That's funny. What time works now? The time of the hearing, that works. That really does work. Before that's before the day is done.
I can't hear you.
Just a second. You're not on speak. Oh yes, excuse me. Yes.
For madam.
Judge Simmons.
Yes, ma'am.
Thank you. I definitely tried to make my appointment, but Zoom was not. I could appear today because I don't want to be in contempt because the eviction notice.
Yeah, we're having a hard time understanding and making out what you're saying.
Oh, okay. I got an eviction notice. That's why
you got an eviction notice?
Yes.
Okay.
That's why I'm in court.
But you were here for a pretrial back in April 12th, and we told you to appear on May 24th.
Yes, I was.
Correct. I said you were here, and you were given a notice to appear today for your hearing. So today's the date and time for the hearing. So you need. to be either on Zoom where I can see you and properly conduct
So I want
a
to go.
hearing.
I want to go faster, just so we can get through this part. It's just an interesting understanding of how court operates and how you should get on Zoom. Just making sure everyone knows that. But the judge is so articulate and keeping her cadence that when we do it too fast, it sounds weird. However, when I guess tenant is on the phone, her cadence is a little slower. It's like, oh, trying to maximize our time here. But listening to the young lady on the phone, she's stating that her landlord has served her an eviction notice, and the judge is just like, okay, come to court, let's talk. In court, I have to see
Or
you.
you have to appear in person, and it has to
Either
be
in
today.
person or Zoom today, no other day.
Because, yes, Your Honor.
And all these other people are just like, can we do our case now?
Have got to get out of this situation. But I thank you for taking the time. What time today?
Now.
You were supposed to be here at 1:30, so you should be here as soon as possible.
Well, they gave me Zoom.
I see.
My
Correct,
Zoom
but
was
it was your
malfunctioning.
responsibility to make sure that you could appear via Zoom. No one mandated that you appear via Zoom. That's an option at your convenience. But if you don't test your functions to make sure your devices work, then you need to appear in person.
Oh, okay. That makes more sense now, Your Honor.
But I don't understand the original confusion to it. I guess maybe now she knows that it wasn't mandated for her to do the Zoom. But we're so far out of COVID.
Weird.
I don't know when this was, but
okay.
How long is it going to
I
take for
do
you to get here?
understand.
maybe she thought.
I'm not sure. My mom and dad just came in from Ohio, so they will bring me into court.
Okay. She has arrived.
Okay, we'll see you shortly.
Sounds great. Thank you, Your Honor.
Today, yes.
Thank
Get in
you.
there. Come to court.
You're welcome. Goodbye.
Okay. Bless her heart. Bless her heart. All right. Now let's see if we can get into some other landlord tenant matters. Make sure you're liking, sharing, and subscribing.
Wait, where's the attorney?
YouTube wants us to do YouTube things.
No.
Like, share, subscribe. So just click. That's it. Okay, just a click away.
On the record in the matter of Joseph Fatale versus Robert Boudreaux, Michael Peed and Chrissy Peed, file number 22-04155LT. State your name for the record, please. Can you state your name for the record, please?
Joseph Fatale.
Thank you, Joseph Fatale. And then I see Chrissy Peed.
Yes, Your Honor.
I see Michael Peed, but Michael Peed is trying to make me dizzy by moving. You need to be stationary and prepared to handle court if you're going to appear virtually, or you got to appear in person. Okay? So you need to go find a place to sit or stand without moving around in a circle. Okay? Today was the date and the time that was set for hearing. I ordered this as an in-person hearing. Why are you on Zoom?
Oh.
Your Honor, last court date, you told me either I had to appear in person, but as long as I dropped off all the documentation, I could appear through Zoom.
Huh?
Dropped off all of what documentation?
All my evidence. You said as long as I dropped it off before my court date, I could still appear through Zoom.
Did you receive a notice to appear?
No.
I have a notice date stamped here that it was mailed to you on April 26th. It says with 3 stars on each side of it, appear in person.
I did not receive that, and I was even at the courthouse on Monday, and they told me it was through Zoom when I dropped off the last piece of paper I had.
There's no possible way the court told you it was in Zoom if they looked at this notice, because the notice that was sent to you clearly states appear in person. Did you get a notice to appear, Mr. Vitale? Okay. Mr. Vitale, how did you know to appear in person?
Because I called to confirm the court date that was originally set, and the court clerk said that it had been rescheduled to today at this time.
In person?
Yes.
Okay. I'm sorry?
I said on the 26th, I did put in the notes that the defendant needs to appear in person. It does not drop off exhibits prior to hearing.
Okay. Who mailed the notices? Why did neither one of them get a
notice to appear. I didn't reschedule.
Well, that's nice of the clerk. The clerk is like, Your Honor, I did have this notation that, defendant, which is Miss Peed, is correct that if she dropped off all of the documentation, she could in fact appear via Zoom. It's very nice. I don't understand why that would be a condition of appearing in Zoom, as if documentation is dropped off, because your evidence has to be submitted prior to the hearing, regardless if it's on Zoom or in person. It has to be submitted prior to the hearing. I mean, the judge and court goes by quickly because they have all the documentation in hand prior to, they read it prior to, they become availed of the information prior to, so that when you start testifying to the effects of what your evidence is to show, they have some understanding and some nexus as to what you're talking about. This right here is a little different, but we're in a new court, so maybe they do things differently. And this is a good thing to take away. You have rules of court, you have your procedural rules, whether civil code of procedure or criminal code, when you have your procedural rules of court, right? You also have rules relative to the judge's courtroom. So one judge may have a particular format that they want the evidence presented. They may have a particular time frame they want the evidence presented, and so they have their own set of rules. They put you on notice when you open, well, maybe not necessarily this particular court, because I've never worked out of this court, but there are courts that will give you a judge's order, general order, as soon as the case is filed, as soon as you're served with the complaint, you receive the orders of the court, so you know what the court requires. So maybe that's something that this court requires, that you drop off your evidence, and then that will give you the freedom to prepare on Zoom. I don't know.
What did you drop off it
Not
to
sure.
the court? Ma'am?
I dropped off, on Monday, I dropped off the Lansing city inspector, the inspection, the report, and then about a week and a half ago, I dropped off
Okay.
the Orkin report and photos.
Okay, so we have inhabitability of the home concerns, and so that's a good reason to hold your funds. So tenant, you may be holding your funds because you feel like the property is inhabitable, that it's going to be condemned. You have the city come out and do an inspection. Maybe there's some real concerns about fire hazards or other issues relative to safety, and they'll do an official reporting, and so you use that as your evidence to the court. This is why I'm holding the rent. But remember, you're holding the rent. You're holding it. You're not spending it. You're not absolved of having to pay it. There may be a moment where you put it in escrow and you hold it in trust for the landlord. So then once the items of inhabitability are corrected, then they receive the funds. Okay, so be careful. Don't hold it and then go buy the Louis bag. That's not how you secure the bag. Okay, that's not securing the bag. Okay, that is debt. That's debt that does not appreciate, does not render any investment to you. Okay, I know we think our Louis bags are going to go up in value and we can resell it and it maintains value. No, you lose money. You pay $2,500 for a small bag and you go to resell it at the consignment store and you're getting $500. That's a loss of money. It's a loss of money. Okay, you're not securing the bag that way.
Except because you requested an inspection, or you requested to have it reset because they couldn't come to inspect the house until after May 18th. Is that correct?
Yes, so there was a problem because Joe originally had scheduled the inspection for June, and that's why they weren't able to come out. There was already an inspection scheduled for June, but I had ended up getting a hold of Everett, the city inspector, and he said he could come out on the 18th to do the inspection.
Not sure who Deb.
Okay, and so we adjourned this hearing previously because you stated that the basement was infested with fleas and mice.
Okay, so that's her complaint relative to the enjoyment of the property. There is an element that is infesting the property. So for my landlords, one of the advices I give them is regardless of you believe this tenant will have a problem with bugs. I don't want to say, oh, I can't, oh, cockroaches, oh, mice, or anything else, any type of bugs or infestation, you always need to have each month have a service come out, whether it's whatever your local infestation. I don't want to give like termites, but I'm not necessarily termite. What is it called? I use pest control. Whatever your local pest control. I don't want to say any names because I'm not advocating for one or another. Just whichever one is best suited. Have them come out and service the property each and every month. Make it a part of the expense of your rent. So if your rent is usually $1,800 and you're spending about $50 or $100 for them to come out each month, then their rent that they're paying to you is $1,600, right? You up the rent based on that. And that way you maintain that service each month, because this way, if there is any infestation, it's not relative to the property or something that you're not doing as the landlord, it's relative to the tenant and how they are inhabiting the property. And then therefore you can say, Your Honor, this is my problem with the tenant. They are causing this. I am doing preventative measures. I'm doing all that I'm supposed to do as a landlord. And the tenant is in fact causing this infestation due to their non-cleanliness or whatever the situation may be. And that can help you gain the property with a quick termination of lease versus having to wait till the lease is ran out.
Like you
Yes,
have
Your Honor.
a inspection
I want my Coca-Cola.
report
I want my soda.
from code enforcement. Did you get a copy of that?
Frozen.
I'm
Frozen.
sorry?
I have not received it. I know the items. I was there. I took notice.
Okay, the landlord is in person because it's the in-person hearing. Ding, 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 ding. And he doesn't have that report, Your Honor. He does not know what you dropped off to you on Monday. That is the problem. Whenever you submit evidence, you submit evidence to the court and the other side. Make copies. You need copies. If there's more than one other side, like 2 other litigants, they get each a copy. So make copies. Not legal advice, just opinion. Oh. I want to make sure you know, don't forget, just commentating. Until we actually have an agreement with one another in writing, I don't necessarily represent you. All of my clients are sign agreements for me to represent them. So please understand this
I
is
do
just
see where it notes that a certified pest controller is required.
my opinion.
You're aware of that?
I actually had a pest inspector twice, and I have the invoices with the note sheets from the service.
Okay,
When
so
was
pest
that?
controller is
The first one was the day after our initial court date, and the second one was
okay.
May
Okay.
4th.
Okay. Well, this was dated May 19th. It says that you need to have a certified pest controller, which was required to exterminate and to provide written verification to the code compliance officer.
I mailed this to him. I
Okay.
emailed this to him. We did receive that.
Okay, I don't see, however, where it indicates that there was any notable infestation of fleas or
Mice,
mice. It doesn't say what it is.
what
Would
the
it be
report?
helpful if
Okay, yeah. Did
Or
you
the-
provide that to them?
she was at the inspection, so.
Okay,
she
but
was-
still, this is why things need to be in person because
Right.
I can't show her what you're showing as
I made a
evidence.
copy set for her.
And then same here, we need to give you a copy of this because you don't have a copy of this.
I don't.
Okay, so now Your Honor is rightfully so perturbed by the notion that it's optional for this particular hearing to occur via Zoom or in person. She believes that her notice was in person. And I guess the clerk may have given the defendant some confusing information, or maybe Your Honor spoke in a way that it was misunderstood at the time, but she's now indicating that her reasonings by why such a hearing should be in person is because evidence is being presented. It sounds like this is like a trial hearing. Evidence is being presented in this matter where the I'm sorry, Chrissy, I didn't mean to freeze you with your eyes closed. It's okay, it happens to me too. It's being presented where neither side has the other, right? They're both saying, I don't have that. Oh, I didn't see that. And so it's like, okay, you can't just say, here, counselor, here, landlord, here, tenant, and just pass it along because they're not in person. And so she really wants people to be in person for this. And I agree, it keeps it simple. Now clerks are running around making copies, uploading.
What is this that you're trying to give me?
Emailing, I don't know.
So I have the 2 invoices from the pest inspection and pest treatment for the mice.
Okay, but what if,
detailing of
okay,
the
so they
traps
did
that
have a
were set
mice
and the poison,
treatment.
and then the
Capture
follow-up report
traps, I guess.
when he came back on May 4th to treat a
Okay.
second time. And that report specified that we should wait 3 weeks to treat again, and I have them scheduled to come back tomorrow, which would be 3 weeks exactly.
Okay, so there was an infestation of mice.
There was.
Okay. And ma'am, what were the other allegations?
I don't know, objection, Your Honor. How do you identify infestation? You find one, is that an infestation? You find 2, 3, or just one is enough? I'm just kidding.
Of habitability issues.
But listen, I'm with you. I don't want none, okay? None. Any of them. It's just enough. And I feel bad for Miss P. But understand, for all the landlords out there, during different times of the weather, you may have a I don't know, so driving by slowly. During different times of the weather, you may have different bugs, show up. And that's why I said you want to have a service every single month. You get it, it's cheaper than when you just have a service come once in a while. If you have them come every single month and you're on their monthly plan, they give you a break in pricing. So that's good. It also helps you to keep the property secure and safe because, like, if it's termites, you want to have a knowledge of that quicker than later and get this service to it fast so they're not eating up the structural part of the home. And then the mice, of course, is so unsanitary and whatnot. And we are closely together. The, panorama gave us that understanding that as close as we are, the closer the cities, the closer the homes in the neighborhoods, the quicker things move from one household to another. And so that's another reason to make sure to have pest control as a service provider. Just like a gardener, pest control. If you only have an apartment, then you don't have to worry about the gardener. You're saving some money there, but always have a pest control if you were looking into being a landlord.
Well, mainly it was the mice because the home is infested with mice. They're everywhere, and they've been here since I moved in. He just didn't tell me how bad it was.
One is so bad. Like, one is so bad. Did you sign? Are you trying to say? I mean, the city is not going to consider that a forfeiture of rights, like a waiver. If you're like, I knew that there were mice when I came in, and I wanted the home so bad I needed it, but I didn't realize it was this bad. No. They're not going to say you waived your rights to live in a safe environment. It is actually a law requirement that it is a safe environment being provided to you by the landlord. So you can't wave that around. But if it's just one, that's horrible. That's horrible.
When I moved in here.
No, poor babes.
There were fleas in the basement, but I did treat the fleas myself, and there are no more fleas.
How do you treat fleas yourself? Well, I guess what?
Okay. Or something? You have animals, though, correct?
Yes, but the fleas, Your Honor, were never inside of the home. They were only in the basement.
That's a part of the home. No, is it not connected? What do you mean?
Okay, so this is a eviction for non-payment of rent. The time of the filing of this eviction, which was back in December, the past due amount was $3,740. What is the past due amount now? I think in April you said it was $10,770.
Yeah. That was
Deborah and I together, baby. We was like, what? 10,000? Like, where does he live? Where is this a lakefront house? Like, what are we doing? Where is this rental property? Well, okay, so December, April, that's 4 months. 4 months into 7,000. what's that, like 1,500 a month or something? Yeah, like 15. Okay, that's not too bad. That's not too bad. But in LA, in Cali, that's not too bad. I don't know about Michigan. I haven't heard rents this high, but it's maybe a full house, and so we'll see.
March, April's rent has now come past due, and so the total is $12,500.
Oh no, 12,000. Deborah, girl, you and me both, honey.
So, ma'am, have you been escrowing this rent, or why have you been withholding it? You can't. Is it because of the condition of the property? Is that your allegation?
You can hold it.
Yeah, the condition of the property, he should have never rented this house, honestly. There are multiple problems with this home. I have lost all of my.
I need to know what the multiple problems are.
But you're there. So be careful, tenants. You're there. You're living in this property months and months and months and months and months and months and months. Like she had arrears in December. Now we're 4 months past that. You're 12,000 up. You start off with 3,000 deficiencies. I hope you have put this money away. I really do, because you're renting it. You're there. You're living in it.
Infestation.
Are you fixing it?
There's water leaking in the basement.
Because what you can, sorry, keep talking about it. What you can say is, I'm fixing these problems, and so therefore I'm deducting my costs for fixing it. I hired this contractor to fix the flooding problem. I hired the contractor to get rid of the fleas. I hired the contractor for yada, yada, yada. Here are my invoices. Here's my receipts for payment. Da, da, da. And I took that off, and the rest of it's in escrow so that when we, that's what you said, you're escrowing the money. So the rest is in escrow so that when this case is resolved, I can give the funds at the end. I just need the place habitable. Okay. But not I can use this to live rent free.
My water bill and my electric alone are almost $600 a month.
What?
Because there's a constant water in my home.
Right.
I have lost all of my.
I need to know what the multiple problems are other than the mice infestation.
Another thing, landlords, is I would suggest, because I do not advise those who are not my clients, I would suggest that in your tenant agreement, the tenant is responsible for having personal property insurance, so that if there is ever a loss of personal property due to damage or theft, that they recover that from their insurance, and they're not trying to recover it from your insurance as a homeowner.
There's water leaking in the basement. My water bill and my electric alone are almost $600 a month because there's a constant water leak, and all my property in the basement has been damaged. He did inform me.
Do you have evidence of that?
Yeah, that is also inside of the inspector report, that there's water leakage. None of the outlets in the home work. When you plug something in,
I have the copy of the inspector's report, but you were supposed to provide me evidence of the condition of the basement, and then show me proof that of your damaged items. I can't possibly order recovery for something I don't know was damaged. You're not giving me an itemized list. You're not giving me pictures. You're just saying all your items. What does that mean?
So down in the basement, all the items that were down there were all my Christmas, all my holiday decorations, all my children's summer clothes, all of my summer clothes, all my.
Okay, her summer clothes. Okay, but the children are going to outgrow them, unless you have children that are close in age, and the eldest child's clothes can go to the middle child, and the middle child's clothes goes to the younger child. Unless you're in that scenario. But otherwise, children summer clothes, I wouldn't put children's summer clothes away like I would do for me. My summer clothes, okay, obviously, we put those away because you're in winter, and then winter comes, you pull out your summer clothes and put your winter clothes away so that you can maximize your closet space. You're using the basement as a storage because you are typically in the same size that you were in several months ago. Children, no, children go quickly. So
my mother's belongings, because she had moved to California right when we moved in there, and I was storing all her stuff down in the basement until she got back.
Yes, but she has to sue for herself to the price of her belongings. And what's her belongings?
Or a flood?
Yeah, there's a constant water leak in the basement, and he did tell me there was a little leak, but he did say it was safe to put my stuff down there. He said the last tenant stored stuff down there with no problem. So I went ahead and put my stuff in the basement.
So you were put on notice that there's water in the basement. There should not be water in the basement. the size of the leak becomes mute in my eyes. Now, how the judge in the court sees it, that's fine. There should not be water in the basement. This is concerning for the structure of the basement because the water is helping to erode. I'm having a rough one today. But the water helps to break down the basement. And that is a part of the foundation of the house is basements underneath, right? It's close in proximity. So that's a problem if something is eroding at the basement, water or otherwise. So no, there's no water that's supposed to be in the basement. Should not have wet damp basement. Always look forward to curing that because over time it's taking away the value of the property because
but it is
it's eroding it away.
Yes, he's known about the water leak since I moved in.
He told her she was on notice. He said there's a leak there.
Okay, when did you notify him that
there's a leak? Just put umbrellas over everything so you can make sure the water doesn't hit your stuff. Come on, for real.
The leak was such that you could not properly store your things there and that your things were damaged.
Yeah, when did you take notice of that?
When they originally came to do the inspection, Joe and Everett, I believe it was back in December or January, I had told him all the problems going on in the house, including the mice and the fleas and the water.
When did you notice the water?
Okay,
why did you make
you moved into this property when?
Yeah.
I moved in 2021.
Oh, hold on.
When did your things get damaged?
So I never went down to the basement really until just this last year. I went down there to go get Halloween decorations. And when I went down there, I was covered in fleas and noticed water all over the ground. And as soon as Joe came in with Ever, I told him, I said the basement was infested with fleas and I can't.
Wait. So you were covered in fleas, you walked down to, and you had all the water and the basement was totally discombobulated and your stuff was damaged and you called your landlord in October to tell them I went down to get some decorations and noticed all of these discrepancies and issues? Or you
go down there anymore because as soon as I go down there are fleas just all over my body.
That's just
okay. So what you're saying,
but are they fleas or something else because the water is there?
Is you went down to get your Christmas items during the holiday, this past holiday season, and Mr. Vitale was coming to the property to inspect anyways, or
exactly.
Yeah,
so call him and tell him about the issue.
No, he came with Everett, the city inspector, to come do.
That's in December, January.
Do an inspection to make sure the house
months
was
later. What are we talking about? What are we talking about?
I'm not sure exactly what the inspection was for.
It just so happened that he was there, and so you notified him then, but you didn't notify him as soon as you found out your items were damaged?
Well, no, not as soon as my items were damaged. I didn't really know that they were damaged because I couldn't fully go down to the basement because of the fleas.
Okay, so have you been able to go down there now?
Yeah, I've been down to the basement now. I bombed the basement with a flea bomb.
Okay, are your items still there, or did you have to discard of them?
They're still down there.
Okay.
I've thrown some stuff away. I rented not a dumpster, but a person came and picked up a bunch of items, but there's a lot of stuff in the basement.
Okay, so the things in the basement are the things that you said that are lost, that they need to be discarded of?
Yeah, everything in my basement has to be thrown away. I'm gonna have to rent a dumpster and throw everything in there away. I cannot keep anything down there.
Who's that, Mr. Peed?
Now he's in a car? Now he's
Mr. Peed is not prepared to.
Did he not hear? I've been trying to keep up with Miss Chrissy. I couldn't keep up with Michael. She said you have to be still. Be still, stationary, upright. He stopped what he was doing, which was walking around, looked like a warehouse, and he went and sat down or stood up, whatever. He got stationary. No, he sat down. Yeah, he sat down, stationary. Now he's in a car. That's worse.
Proceed with the court proceeding. Here's two things. Number one, I'm going to remove him from the virtual courtroom, and you all can appear in person. You need to bring me pictures of the things that you said are going on in this basement. You need to bring me other evidence, and I don't need it on a phone. I need printouts of the other evidence other than the infestation. I also want you to bring me, Mr. Vitale, evidence that you provided compliance, the compliance.
Mr. Vitale, and I think there's two landlords, but Mr. Vitale, the landlord, whomever, I know is like, oh my God, really? we're gonna we spent the first, I don't know, 10 minutes talking about how we are not, oh no, that was a different case. But the other case got to know that they had to come in person 2 days. It had to be 2 day, no other day. But we're going to continue this hearing. Really, when she was told at the last hearing to submit her evidence. Oh wait, I don't like this picture. Let me, okay. It makes it look like something else is going on. But yeah, so we're gonna wait. We're gonna continue it. And we're gonna have another hearing. Come on, Your Honor, please. I just want my property back. Make the girl pay me my money. Judge is like, no, prove to me.
Officer, you provided compliance, the compliance officer with the verification that you took care of the past issue, because this said you had to do it by the 18th of June.
I have that.
Okay,
You have that there. That doesn't tell me that it was provided and that they sent you a letter of compliance, because that's what they have to say.
All of these items would need to be done for a letter of compliance.
You gotta do it by the 18th. Your next court date won't be there before the 18th anyways.
What's the problem? Didn't he say he already took care of it?
Sooner than you've complied?
Sooner than the 18th of June.
We can do it sooner, but then I'll have to find that you're not in compliance.
Well,
with the property.
I would have the opportunity to be in compliance before the next court date.
Oh, he's trying to speed up the process. He's like, can we not wait until the 18th, Your Honor? Can we do it sooner? I will comply. I will prove my compliance. Can we just do it sooner? She's like, how are you going to be able to comply prior to the 18th?
You said you would have the opportunity? If you're in compliance before then, you have a compliance letter.
Yes.
Absolutely, but I can only do it on a date that I'm available to do it.
Is the 18th your soonest available date?
We can do June 7th at 1:30.
All right, Miss Pete. I hope you have your
June
fun.
7th at 1:30, you need to be in person at the court. There will be no, I didn't get a letter. I didn't get a notice. I dropped off something. I'm not going to be shuffling around your exhibits on your behalf. You need to bring them in court and be prepared to present your case. Otherwise, I can't grant you the request that you're seeking, which is relief as to what is now a $12,000 past due rent, okay?
Yes, Your Honor.
Mr. P needs to come in person with you. Otherwise, I'm going to issue a default judgment against him, okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Okay, any additional questions from you?
May I have a copy of the default judgment against Robert Boudreaux? I didn't receive.
Did you submit a default judgment?
He didn't show up for the first court case.
You have to submit the default judgment for me to sign.
Okay.
If we can print it out now and you can fill it out and I'll sign it.
Okay, that'd be great.
Okay,
Thank you.
no problem. Any additional matters for the record?
No, Your Honor.
Anything else? Okay. We'll see you on June 7th at 1:30 in person.
Okay, thank you.
You're welcome.
Okay, thank you. Thank you. Thank you. Okay, thank you. Thank you. Come in person, madam. All right, who's next? Well, I don't know who Deborah Searless is,
Ms. Farrell,
but
Yes, Your Honor.
are we ready to proceed on that? I don't see Mr. Axel though.
I have not yet spoken to Mr. Asquith on this matter yet. I believe he's still in a breakout room with another tenant.
He is, okay, when he's available, I'll put you in the private meeting room.
Okay, thank you.
Asia Edmond,
Yes. Yes, I'm here. Can you hear me?
yes, I can hear you. I'm gonna mute you until the plaintiff's counsel appears.
Okay.
So take this time to like, share, and subscribe. Like I said, I'm not sure Deborah's position in this matter, but they're waiting to get to the next case. And they need the time in between cases because they're making the notations in the last one. So it's why it's always a lag between one case versus another. Let's see if we can fast forward a little bit or speed up a little bit while they do some ancillary things. Do some housekeeping. Let's do our own housekeeping. Like, share, and subscribe. Hello, hello. Did you guys check out the live video that we had the other day? That was great. So much fun. Check that out. We were live at Judge Middleton's court, and we had a good Am I the A-hole? AITA with the fence, right? Neighborly love. We had some neighborly love. Looks like we had the UK probably. And I want to know your opinion. So go check it out and let me know what you think about the AITA on that. Okay, let's see if we can get Deborah's back. Deborah's ready for court, Your Honor. She's ready. She's ready for court. Say, please go my case. I'm ready.
Mr. Ashcroft, are y'all set in the breakout room?
I am, Your Honor.
All right. Might be getting on the record soon. Let's see.
He's not in there anymore. Okay, I don't know if the tent. I'm sorry. I don't know. What's your name, sir?
She's asking your name.
Possibly.
Oh, okay, he's in the courtroom. Okay. We're on the record in the matter of Cedar Place Apartments versus Paul Shebley, file number 23-00444 LT. Counsel appearance.
All right.
Brass 53129 for the plaintiff.
Thank
Plaintiff's
you. Mr.
counsel
Shebley
is
is
there.
present in
Plaintiff is
person at the
the
court.
landlord.
And are you with him, ma'am?
Yeah, I'm a community mental health caseworker who's helping him.
All right.
Okay, today was the date and the time that was set for a hearing for non-payment of rent. Mr. Asphalt, could you all come to a resolution?
Yes, Judge, we have the terms of a consent judgment that I'd like to put on the record.
All right, consent judgment.
Your Honor, there's currently rent due and owing of $1,482, late fees of $148.20.
You hear that? 1,000 something. That sounds like Michigan rent. Miss Ma'am, at that $12,000, I hope you are putting money aside so that you can stay. Otherwise, that's going to be a judgment against you.
Court costs of $155 for a total amount $1,785.20. The defendant is to pay that amount on or before June 5th. If the defendant fails to pay that amount or vacate the property, then plaintiff can move for entry of an order of eviction.
I hear you. We got.
Okay, Mr. Shebley, did you hear that? Did you hear what the attorney just said?
She's wanting to know, did you hear what he said about the fees that you want?
He wasn't listening.
Okay, and
I wasn't
you
listening.
understand what was said?
Yes.
Okay, and so you want to enter a consent judgment?
Can I get an adjournment?
Okay, why do you want an adjournment, sir?
So I can talk to the people that we're working with towards getting the rent released. I got DHS is giving me $400. St. Vincent is $850, and we got a couple more places to look at.
So
Okay.
DHS is going to give you how much?
410.
410, and then St. Vincent's going to give you $850.
Yep.
And when are they going to do that?
We have a meeting with them on Friday, and we need paperwork from today to present to them.
You need a judgment?
Just whatever the new balance would be, because the other balance is higher.
Okay.
Yeah.
So you needed a statement or a ledger of the balance in order to get this assistance? Okay. Did you meet with legal services last time you were here?
I did not. I only talked to the gentleman.
Mr. Rosa?
Yeah.
Okay. So you understand that you have the right to be represented by an attorney?
I'm sorry.
You have the right to be represented by an attorney.
You understand that?
Huh?
Do you understand that you have the right to be represented by an attorney for this? Okay. And so you did not want to see if legal services could represent you?
Well, I will if I can't afford an attorney.
Well, they would do an intake to see if they could represent you for free, sir.
Oh, yeah, I'd like that.
Okay, and so I'm going to adjourn this.
I believe he spoke with
Because-
legal aid on April 11th, Your Honor.
He did not. I have a note in here that he did it. That's why I asked him. And so I would not be able to enter a consent judgment if he's not going to waive that right, but I have concerns that he even understands the right to representation of counsel. So I'll see if I can get you intake taken care of. Ms. Taylor, are you going to be available after you meet with Mr. Asphalt?
I can take his information and have one of our law students over the summer reach out to him.
Okay.
You have a telephone, Mr. Chubley?
She's gonna try to hook you up with a lawyer. Do you have a telephone, they're asking you?
I don't.
He does not
He's
have,
down right now,
he doesn't have a phone number right now.
but I can give Maria's number.
He usually comes to the agency 3 times a week, so we usually have him meet people at the agency, at Community Mental Health.
Okay, so yeah, he would have to try to arrange to be at the agency to receive that phone call. So it could become probably taxing if you don't know what time he's gonna be there.
We could set an appointment.
Set up an appointment that way? Okay, what I'm gonna do is I'm going to have Mr. Asphalt and Ms. Till meet about their matter, and I'm gonna take your phone number, and then Ms. Till can make arrangements to have someone make an appointment to do an intake for Mr. Shebley.
For legal services, intake for legal services. What she's saying.
Thank you, Your Honor.
A new date, please. June 7th at 2:30 will be the new date for this.
So no stipulation on the record.
Ms.
Nope.
Till, I'm going to move Mr. Asphalt to room 1 with you.
Okay, perfect. Thank you.
Thank you. Mr. Bigelow, can you get her a post-it note so she can get her number when you get a chance? The caseworker, yes.
Legal services gonna talk to him on the side.
Oh, can you state your name for the record again?
Maria?
Where-
Spelled the common spelling, be what?
Or
Yes.
talk to, I guess, Asphalt, legal services and the landlord representatives speak on the side. So that's
Okay, Mr. Wassery,
good.
you're here on the Asia Edmond matter.
Yes, it's a 2:05.
All right, that
You met
matters
with her already?
over
She's on
for
Zoom.
now.
Oh, I haven't met with her.
And so basically what he was putting together was he has different potential programs that are willing to pay the rent or pay portions. One says 410, the other one says 800, and I think there's still like another 600 some odd dollars and needs to be paid in order for the $1,800 to be cured. I believe that's what it was. But nonetheless, he does have some help, and he's trying to get the paperwork so he can get the help. The attorney was trying to get a stipulated agreement on the record of how much is owed and get things done that way so that both sides agree to the amount, which I guess is simple enough, but the judge didn't let them go that far. She's like, nope, he's going to apply for legal services and get proper representation prior to stipulating to the agreement.
She was here.
Okay, Ms. Edmond, you do not have an attorney, correct?
No.
Okay, nope, she's on Zoom. Do you have a device? that You can get on Zoom?
I have my phone.
Okay, if you can log in, we'll put you in a meeting room with her.
Okay, will do. Judge, what's your Zoom ID, please?
876
876.
493 1931.
This, I wanted to get into another courtroom because I love Judge Middleton Court. It's very organized, it's lovely. They let me know it's consistent and I can get in and we all the fun activities there. I wanted to see about another courtroom. So that's what brings us to this court today. Hopefully you are enjoying Madam Simpson's court. She seems reasonable, articulate, of course, intelligent. And so it's enjoyable to see another judge, you know, in Michigan. Michigan is holding it down for us on Zoom court. Love you, Michigan. Keep up the good work. And I hope some other courthouses, you know, open up because this is what it is. This public, it's meant to be public, not to scrutinize, not to be judgmental, not to defame, but to learn. It's a great opportunity for us to learn from others. Unfortunately, they're before the court. Usually that
I see an
means,
individual identified as Annette.
usually that means something went wrong. And so it's not the best circumstance, but we can
What's your full
learn
name?
Annette Richards Mendez.
something is always a takeaway.
What are you here for?
So
Oh, I see you.
we've
Annette
learned
Richards
court
Mendez.
decorum
Okay.
on Zoom, a great deal, different ones, like no walking around,
I
no
see Autumn and Devontae.
moving cars.
Yep.
Laying down, we've had people laying down in court. No, none of that, none of that. And come in person.
Anyway,
There are times when you must
let me
come in person. Zoom is a privilege, but not
Can
a
you just one moment,
requirement
Mr. Waltery? I vote
and not an absolute.
Thank you.
There are times you need to come in
Ms. Edmond will
person.
put you in room 2.
Don't
Okay.
overwork the court staff by having to make copies and don't want the judge shifting through your paperwork. And you should be labeling exhibit 1, 2, 3, 4, 5, so that you can say exhibit 5, your honor, is what we're looking at. Exhibit 6,
Your
your honor,
Honor.
is what we're looking at.
You're muted.
All right.
Yeah, I'm Autumn.
Okay, and where's Devontae?
He's walking down the hall.
To come to court? Where's his device? I think that that's another thing to consider. You might want to know for your court. There are some judges that want, though you are co-defendants or co-litigants, you're both being sworn in, they want you to be on 2 separate devices. If you're a witness, they want you to be on a separate device. So even if you're in the same household, go to separate places so you don't have the feedback. Oh, wow, the feedback. I saw that in Judge Bryant's court, and the mom, this is not real estate centered, so that's why we didn't go over it. The mom had an order to stay away from the child, to not be with the child, her own child. So take that into major consideration. The judge has ordered you to stay away from your own child. There must be a reason, right? There has to be a reason, especially with the mom and the child. That's usually a very important relationship that the courts uphold very dearly, and they do care for the father's relationship with the child as well. I'm just saying, usually most of your resources come from your mom, especially when you're really young. So they want to keep you connected to the mom. But no, she was to be separate. And oh, that wasn't Judge Bryant. That was Judge Manning, actually, Judge Manning's court. And just so happened they wanted the child to testify. They wanted to get a confirmation of if the incident did occur, whatever the incident was. They wanted the child to testify. The child comes to testify, and the child is getting feedback. And so the assumption is that the child's near something that's causing feedback. And so they express to the child to move away from whatever's causing the feedback. And the child and the mother on 2 separate devices begin to move. And it becomes real apparent that they are in the same household. So the mother violated the court's order. So sad, so sad. So the facts of that case is sad, not relative to real estate, unless you're talking about square footage of a home, right? The bigger the home, sometimes the better, so that you can be further apart from each other. But in court decorum, they do want to have witnesses on their own devices, litigants on their own devices, so they can be sworn in and can be seen. And so that as we see them here, we see Autumn and Devontae on one screen, but actually Autumn and Devontae are 2 people, unless they're having a Floridian moment.
When Mr. Axfalk is available, let's see, is that Mr. Axfalk's matter? I might have made that up. Yeah, that was Mr. Axfalk. He's busy today.
Annette is doing well. Her phone is propped. It's not shaking around. We're not having earthquakes.
What time are they saying?
She has
Okay.
a blank background. She is upright and she's ready for court. Autumn is ready for court.
Who's the attorney for Woodbury Department is available. I'll put you in a
I
private
don't know where
meeting room
Devontae
with
is.
them. Devontae needs to be present and on the screen
Down the
at
hallway.
time, okay?
Come on,
He's
yes.
not
Come
available
on,
right now, so
Devontae.
you're fine, but when he's available, you both have to
There
be
you go.
here,
There
okay?
you go. There you go.
Okay.
All right. There you go.
And then I have
Put your
Annette.
phone sideways so you can see. Does that work for Zoom? Put it sideways.
Okay, this
I think you can.
Kilo Armstrong,
Yes, Your Honor.
we're on the record
I'm not here.
in the matter of the people of the city
No,
of
ma'am, I'm
Lansing
not a part of
versus
this matter.
Kilo William Armstrong. I have 2 files. They were file number 23-,
William Armstrong and I are not related. We do not know each other.
4432.
I want the record to reflect.
Yesterday was the date you were supposed to appear for explanation hearing. You were scheduled to be before the court at 9 o'clock in the morning. It looks like originally the matter was adjourned to allow you to fix your place.
What are we talking about?
And
Oh, okay, this
wanted
is
time.
not
I've had
relative.
like 3 different court dates.
Not relative.
Have a seat. What we're gonna do is see if we can find a city attorney.
Gives me the impression that we're in landlord tenant docket and this litigant walked into court and seemingly was supposed to be there on a different day or a different time. And they're taking a look at his case for the judge to, I mean, they gave the case file to the judge to take a look at it and to give some kind of update to him. But that's not relative to this case. His DMV matter does not pertain to the landlord tenant hearing.
And see how they want to proceed.
So we can get past him.
I don't know if Mr. Armstrong is in the courtroom.
I guess we're waiting for who I think Annette seemingly is the landlord. Autumn and Devontae are the tenants, I would presume. Not sure if we're waiting for an attorney. I don't know what we're waiting for. Call this. Okay. Oh, okay. So we're waiting for the attorneys to get out of the breakout room on the last matters, I guess.
Ms. Till, are you all set to proceed?
Yes, Your Honor.
Okay, so she's
Your
legal aid.
client has not started her audio.
Oh. We were able to talk earlier. Do you want to put us in a breakout room? Oh, I think she's going again.
Someone needs
Her
to start their
text to connect is failing.
So, wait, so that's an understanding that the last or the very first tenant was coming to, or at least the judge was trying to get her to understand, was that it's the responsibility of her to check her connection to Zoom. That's including audio and video. Both things need to be enacted. It sounds like someone is on, but their audio has not connected for whatever reason. And trust me, this happens. I don't care if you're on Zoom all day long, right? And then the next minute you get into court and all of a sudden it doesn't work. You could have did a seminar, you could have, taught a class, you could have done prayer hour, whatever. Oh, Judge Bryant's prayer hour that she does. I love it. It's such a great expression of humanity. And to see that the judges are people, to understand that they're people and they're not just judges with the iron fist. So she comes on a little early for me because she's Michigan hours. And so she's like 4 o'clock, 4:30 my hour, but check that out on her channel. It's good to have prayer warriors throughout the judicial system, especially it seems like it's being attacked in so many ways right now. But nonetheless, you gotta check your audio, you gotta check your camera, your connectivity on Zoom. So always be early so you can check it. Check your mic, do your mic checks, right? That's the same thing that happens in music, right? They mic check no matter what. You gotta check it because it will act silly.
If it helps, we are intending to ask for an adjournment, so you won't need to take her testimony, but if you want me to try and troubleshoot with her, I
said you get the adjournment.
Nope, we can go on the record. We're on the record in the matter of Cedar Place Apartments versus Deborah Searles. File number 23-00436 LTE. Council appearance.
Chris Perez, all for the plaintiff.
Felicity Hill for the defendant, Deborah Searles, who is with me via Zoom.
It was a date and time that was set for hearing.
Oh, Deborah. Wait, Deborah been on all day and now it doesn't work. So see, that's the whole point. So Deborah has listened to phone calls. She has been on other people's cases, and now it's her turn and her connections all of a sudden.
We're requesting an adjournment.
Correct, Your Honor. If we could get your soonest available date.
Yeah, I'm sorry. I was going to suggest the June 7th date, if that's possible, Judge.
Oh, and another thing is when you go on breakout rooms and come back, you're usually muted by automatic default. So you have to be able to unmute. So if your phone is broken and you can't unmute yourself, you might get yelled at by the court. So I'm sorry, speaking from too much experience, huh?
June 7th is wide open. At 2:30.
Use the devices that work and have full functionality,
work?
or learn.
Yes, that's good, Judge.
Okay, we'll adjourn until June 7th at 2:30. Any additional matters today?
No.
No, Your Honor.
Okay, you're all set. Thank
On the
you.
shortcut.
You might want to
Okay, so they do nothing.
um,
Okay, yeah. Great.
room now.
They did adjournment. They took that. Deborah's back on now. Deborah, we got you, girl. Good, you adjourned. So that was going Miss Inette and Powell and Leggett litigants. And it presumably the court likes to have the litigants up before they actually call the case. And so maybe that's why they've been up so long. All right. Autumn has fallen off. Autumn and Devontae. Another reason why you need your own devices, because if Autumn's device runs out for whatever reason, Devontae has his own. Now they're both
not yet.
They're
Thank
both
you.
off. So you both are either on together or off together when using one device. All right, Deborah's gone. All right, Deborah, have a good day, Ma. She was dying with me. $12,000. Who do you think you are? Who do you think you kidnapped? Chelsea Glip. Makes me remember Rush Hour. Oh my goodness. You want any thighs with that? $12,000 rent, child. I bet she's gonna get everything she can to prove damages. So she doesn't pay her $12,000. Okay, Aisha, like the girl we never had. Deborah back. Deborah is counselor. You need to call Deborah. She doesn't know that her case has been adjourned. She could not hear you. All right, Sherilyn. Sherilyn Smith is here. Hi, we are here. We are all here. We're on YouTube together. Okay. So we do YouTube things. We like, we share, we subscribe. All right. We take care of YouTube business. We're on YouTube in Michigan Court at
Sherilyn Smith.
54A. Smith. All right.
Okay, do you have an attorney representing you?
I don't.
Have a what?
Okay, the landlord, Annette Richards Mendez, is present. Today's the date that's set for a hearing, but before we proceed to a hearing, I usually put the parties in a private meeting room so they can discuss whether or not this matter can be resolved by a consent judgment or a conditional dismissal or any other agreement that you come to, okay?
Okay.
Do you believe, Ms. Mendez, that's meaningful? You can unmute, please.
We can try.
Okay, if not, come back and we'll proceed with your hearing.
Oh, that's so nice. She's like, we can try, sure, Your Honor. And all courts want you to be able to either mitigate the damages, lessen the damages, lessen the cost, and to mediate. These are important aspects of each party to try and mediate. They really want you to solve the problem without their intervention, because then that way you both have agreed upon it. It has a favorable outcome, and the court did not have to take a side, in essence. So it's really good to be able to mediate. And so they're going to try that. Judge says, this is the way we do it. I put you to breakout room. Hopefully it's meaningful. Hopefully you'll be able to come to a meeting of the minds, have a new agreement of whatever. Get out today, tomorrow, the next week, whatever, pay the rears, whatever your agreements are. And then if not, then we'll go ahead and apply the law and intervene.
Okay.
Nice way of handling things. But that's every court. Every court wants you to try and mediate the situation. And that would be better. It would be so much better for the tenant, especially so they don't have it on their record.
-006.
On behalf of plaintiff.
Ms. Edmond, are you there?
Yes.
Okay, very good. Today's the date and the time that was set for a hearing. The parties met privately. Were you able to come to a resolution?
Yes, Your Honor. Total rent retained possession is $2,870.25. Costs are $165.56 for a total of $3,035.81. It includes June rent, and Ms. Edmond indicates she can pay all of that by June 5. After that date, if she didn't pay, we could come back to the court and seek a writ. I did advise Ms. Edmond of the 3-day rule, as well as her 10-day right to appeal. And I indicated I'd be asking her on the record if I could sign her name to this consent judgment.
Okay, Ms. Edmond, can I see your face, please? Okay, is what is being said here accurate?
Yes.
Okay, so you're entering a conditional dismissal or a consent judgment? Okay, so you're agreeing to do a consent judgment?
Yes.
Okay, so before you can enter a consent judgment, you have to waive some of your rights. You understand that you have the right to be represented by an attorney during this eviction matter?
Yes.
Okay, you want to waive your right to representation today, ma'am?
Just meaning I don't need an attorney.
It's saying yes, you want to proceed without an attorney. Is that what you want to do? Okay, and you also have the right to have a trial in this matter, or you can proceed to hearing today. Do you want to waive your right to trial in this matter to enter into consent judgment?
No.
Okay, so you want to have a trial?
No, I mean, yes, I'm sorry.
Okay, no.
Miss Aisha is trying. She's like, Judge, what he said was right. Please don't make me explain. And I don't want to talk about it. No, I don't want to have nothing else. We just want to consent. I concede. This is what I owe. I'm going to pay what I owe. And that's what.
Don't worry, just want to make sure you understand. Okay, so you're entering to agree, you're agreeing to consent judgment to enter in the amount of $2,870.25 rent to retain plus cost of $165.56 for a total due of $3,035.81 to be paid by June 5th, correct?
Correct.
Or you will vacate the property by that date. You understand that?
Yeah.
Whatever's vibrating, Ms. Smith, you need to stop it. Okay. Anybody threatening you to get you to enter into consent judgment and waive your rights today?
And I feel bad for Miss Smith. I have 5 children, so I get it. I get it. I get it. The babies are there. And it seems like the baby is either being audible, so they're maybe disrupting in that manner, and now they might be pressing buttons or doing something else is getting shaking and vibrating, and it's actually interrupting this other proceeding. And it's kind of like, it's a baby, you know, what can I do? So the courts, I have seen courts online who admonish a mother for bringing their children, during which time it was because the mother was going to be arrested. But at the same time, the mother had to be in court, right? And so, you know, not everyone can afford babysitters, and not every father is as wonderful as my husband, right? So maybe you can't leave the children behind. And so I've seen it. And I know in California, we have, at least in our major courthouse, we have daycare for the babies. I bring my child. I did. Thankfully, I didn't have loud children. My children were able to be, you know, contained and quiet, so they weren't disruptive. But I have brought my child to court. We have sat in the, I think it's the gallery where I go to the podium to speak and to carry. And so I've done it, and I've gotten away with it. No judge has kicked me out. And that's with having the daycare. In this scenario, because atypically children are not allowed, it would be a bigger benefit to put the child in a pen, in a care pen, and then give them the toys and stuff, and then go into another room, just so that you can have maybe an eyesight to them, you know, using the door, but obviously having the privacy, or at least the containment of privacy, so that you can go to court and not get yelled at by the judge.
No.
Has there been any promises to you to get you to waive your rights?
No.
You have 3 business days from today to return to the court. If when you leave here, you realize you misunderstood any of the rights that you're waiving in order to enter into consent judgment, you can return to the court and request to have this judgment set aside, okay?
Okay.
And then we'll set it for a hearing. Lastly, did you give Mr. Wasbury permission to sign your name to the consent judgment?
I did.
Okay, do you have any questions for the court today, ma'am?
No.
Any additional matters for the record, counsel?
No, thank you, Judge.
Thank you, you're all set.
All right, Aisha got through it. She got through it. Poor thing. Just like keep it plain. What you mean? Yes, I'm good. I understand. Sometimes you're like, wait, what do you
Thank you. No problem, thank you.
slow down? But they have to. The court has to go through and make sure you understand what you're doing.
Oh, yeah,
I
and
can't
this
give you
is
legal
if they
advice,
to the,
but you can get the
deputy
legal service
superintendent
aid
director, 'cause they may be out.
involved. And if you qualify for that, they can give you legal advice. They can explain to you what it means more than the court can.
Ms. Mendez
Ms. Smith?
and Ms.
Yes,
Smith,
ma'am.
did you come to a resolution?
We did not.
Okay.
It was written over all over Miss Mendez's face when she came back from the breakout room. She's like, no, that's not resolved.
On the record in the matter of Annette Richards Mendez versus Sherilyn Smith. This is file number 23-00475 LTE. The parties are present via Zoom. Ms. Mendez, state your name for the record.
Okay, Autumn has
Annette Richards Mendez.
back.
And Ms. Smith, please state your name for the record.
Shirley Lee Smith.
Okay, today was the date and the time that was set, and this is for an eviction for non-payment of rent. Ms. Mendez, what is the past due amount?
For the rent, it's $7,200 currently.
Okay, and what months does that include?
That's October through May this month.
What about June?
Okay, and Ms.
8
Smith,
months.
okay, 8 months. Ms. Smith, you don't believe that you lawfully owe that past due rent amount?
I do agree.
You do?
I do agree that I owe that much, yeah.
Okay, so then that sounds like a resolution to me. Because you don't have, do you have a lawful reason why you aren't paying the rent? Are you making an allegation about something?
I mean, I've tried to call and get help. I have called like a couple places to try to get help. St. Vincent.
Okay, so the judge is like, okay, wait, she agrees she owes this amount, so you've resolved it. She agrees you don't need court intervention for that agreement. But Ms. Smith is saying, yeah, I owe it, I can't afford it.
Denied me. I am on a waiting list for another place to try to help me, but I just am on a waiting list. And then like I said, I'm a single mom of 5 kids. I've been trying. I only get paid maybe $250 a week.
5 kids like me.
And then I have to pay for my daycare out of that too. So on top of, you only get paid that much, I basically can only afford my bills. So I am.
I would say, because looks like she has at least a baby, or I can hear a baby. So I assume there's a toddler or baby aged child. I would say, in that scenario, maybe you should look at opening a daycare. Maybe that will help.
Behind that much because I can only afford the bills to keep my power on for my kids. So.
Okay, I understand the concern. Unfortunately, though, you're not providing me with any lawful reason while I can allow you to retain possession of this property without paying rent. Okay? Right. So with that being stated, I have no choice but to grant possession to the plaintiff in the amount judgment to enter $7,200. Was there cost associated with that, Ms. Mendez, for service or something? For cost?
Oh, did I add the court cost?
Correct.
That's just the rent. I mean, there's the $250 trash citation from the city from a couple years ago that hasn't been paid. And then it would have been.
Did you include that in this filing?
I did not. I mean, originally I included that portion, but I didn't include the $130 plus the 29 and change.
Okay, so she's now, and not to be judgmental of Ms. Mendez, but she's kind of it's not articulable and intelligible for the court, because the bottom line is the court is saying, do you have cost? Cost are like she said she did give her the example, the process server. So what was their cost? $75. Another cost could be the filing costs. And if you had attorney fees, those are things that come on top of the actual rent. She's talking about things from a couple years ago. I don't know if that is, in fact, Ms. Smith should have legal aid, at least speak to the defense to that. Something that's a couple years ago might be out of statutory limitations for recovery. So I'm not sure if that's going to be applicable unless there was some agreement to pay. And most landlord tenancy scenarios, the landlord pays the trash pickup. And so then that might be another thing that I would say, you know, we're not responsible for trash pickup. However, it could in fact be that the tenant had so much trash or had a violation in that, in terms of putting a non-recyclable good in the recyclable bin. That could be an issue, or putting extremely bulky items that require a different type of pickup versus a regular trash pickup. That can be an issue. And it sounds like there's a citation relative to the issue. So then it's like, well, prove that it was me and not someone off the street, unless Ms. Smith can, you know, just conceded to the fact that it was her. So, you know, having a legal aid, even in this scenario, might be good for her. An attorney might be good for her, just to argue like those little points, so she doesn't get taxed on these extra costs. It's not as if she can pay the $7,000 as it is, so she doesn't need any extra costs. And then I would just implore Ms. Mendez to waive those costs, because she's not going to recover her funds.
For them to, you know, deliver the eviction notice. So I didn't include that amount.
I see a service fee of $29.54.
$29. Okay, mine's
yeah, that was. Yep, and then the $130 I believe was when I filed all the paperwork.
Yeah, that's a cost.
Okay, and so money judgment, you did request a money judgment to issue. I see that on your complaint. Let's see here.
And then I didn't know about any damages if it exceeds the $850 for the.
Okay, so for landlords in this regard, that's something that can be handled later. What happens is that you get a judgment for your arrears. You get a judgment for the costs that you incurred for fighting to get your arrears. So that's why they're asking for your filing fee and your service fees and whatever have you. And so you have that judgment, the tenant leaves, and then you determine if they have big holes in places and you know, there's cement down the sink or whatever have you. Then you go and you file relative to destruction of property damage.
Security deposit.
Okay, so what we'll do is we'll reserve your money. We'll set it for hearing on the money judgment, because you may not know until after she vacates the property. And so what I'll do is set it for hearing on that, but I will grant you possession judgment in the amount of $7,200 for past due rent. You also get judgment for the past due rent plus the service fee and the filing fee. Let me add that up for you. And that the issue of the trash fee, I need a bill or a copy of the proof that that's what you paid.
Okay. And would I just email that to you, or?
Well, you could send it to Judge Simmons courtroom at lansingmi.gov.
Okay.
Okay.
So we'll enter a total $7,359.54. I'll note here that plaintiff
get into Miss Autumn, but it looks like we're gonna have to break this up.
Money judgment to enter after the time you have inspected the property. What is the writ date? Okay, the writ date is June 5th. So ma'am, you need to either pay the total amount of $7,359.54 or vacate by June 5th. Otherwise, Ms. Mendez can by law request to have a writ of execution issued so that she can remove you from the property, okay?
Okay, so what's today, the 24th? So how many days is that?
The statutory time period is a 10-day period. So the writ date is the 5th. If you're working with any organizations that you believe are going to grant you that money, you and Ms. Mendez can come to your own agreement, but that you've not provided the court with any recourse other than to grant possession, okay?
Okay, so 10 days.
Correct.
And, okay.
Do you have any questions?
No, I just didn't know that it was gonna be 10 days after, because I can't get into a homeless shelter for like next 2 weeks, so.
I recognize that, so that by law, I only get 10 days. That's what the law gives me. But you and Ms. Mendez could have worked out another time frame. That's what I put you in the private meeting room for. So you could have requested then, ma'am, I agree, I owe this money, but can I get 14 days or 30 days, whatever? And then that's up to her if she wanted to grant that. But you all did not come to a resolution. So I'll ask her here on the record, Ms. Mendez, are you willing to give her any time beyond the statutory 10 days?
I already told her about the 10 days, a week ago, and this has been a eight-month process of not receiving any
That's a
money.
no. That's a no.
So,
Okay, so
I mean,
that is construed as a no. So the writ date will issue as a.
You know, the landlord, bless her little heart, she does not want to perceive to be crude. She knows that her tenant has 5 children. It has been stated on the record. And by golly, Your Honor, please understand, I've been waiting 8 months for possession, and I've told her last week it would be a 10-day period. I gave her this knowledge that, it would be quick. She would have to vacate quickly after the hearing for today. So she had extra notice beyond just today's hearing. Listen, yes or no, it's okay. I get it. Most people get it. Anyone who has bills and, just think about it this way. If you're working for an employer and you're going to work 9 to 5 each work day, and you submit your timesheet and the employer says, okay, I'll get this, I will pay you in 8 months. Each month, I will pay you and I'll pay you later. I'll pay you later. After a while, unless you're, volunteering or you're building at something, after a while, you're going to typically go look for employment elsewhere, report the issue with the authorities, because you've got to put food on the table, right? So, like I said, unless you're a volunteer or you're someone that's building a business with a family and maybe you understand that the contract didn't come in and you have a different circumstance, it's very unusual that someone's going to be waiting around 8 months for their money. And that's what a landlord is. They are not an employer-employee with you, but they are a business, and this is how they put food on their table. And so they need you to pay for your rent. They can't wait 8 months. So we get it. We don't want to give her 30 more days, no problem. But I don't understand the lack of wanting to give her the extra 4 days, unless Ms. Mendez just does not believe Ms. Smith is being honest with her and is maybe taking advantage. That might be a reason why she's like, nope, statutory limits of 10 days is all I'm willing to do.
June 5th, okay?
I don't know.
Okay.
Any additional questions for the court today, Ms. Smith?
No, I probably would have had earlier time to get help for it, but she gave me a fake eviction the first time, and then I asked her to go get a court eviction because I got denied the first time for help because she gave me a fake eviction.
What? Okay, but this current eviction is not that eviction, correct?
Yes, ma'am.
Okay.
I could have got help back in January if it was a real eviction then. So all these months that we've been waiting, I could have then got help for it if it was a court eviction.
Okay, and I'm not sure what you mean by a fake eviction. I don't know what that means. Did you have another eviction pending, Ms. Mendez?
I just gave her paperwork. I didn't know that it had to be something specific from the court. So
okay, so you didn't realize that you had to file court paperwork and you had to notice to quit.
So what she's saying is, I gave her a notice that I wrote up, I typed up. Maybe it was the form, maybe it wasn't a form. I gave her a notice to pay or quit, to give me money that she owes lawfully and rightfully, or to vacate the property. And so Ms. Smith went to whatever locations she knew to try and get assistance, but because it was not filed with the court, it was not enforceable legally. So those particular services were not availed to Ms. Smith because they felt like it was not an enforceable eviction. And then once Ms. Mendez was informed of that, she went back and filed.
And then once she said that wasn't going to work. So, this whole time I've been trying to get what she needed.
So this is why Ms. Smith, we didn't know. We didn't know why Ms. Mendez did not want to give Ms. Smith 4 extra days at the very least. This is why, because she's been giving her months. She gave her the paperwork in the beginning that turned out not to be sufficient. She went to the courthouse, got the legal documents, and she's been waiting for several months now. I think they're in the month of May. Yeah, because they're talking about June at the end of May. So they've been spending 4 months trying to get this done. So Ms. Smith has been hoping to get assistance all this time and has yet to do so. She's on a wait list. And Ms. Mendez is like, okay, I don't want to wait anymore.
You know, jumping through all the hoops, so that she could get extra help, and by, you know, all the while not even receiving $50, $100 a month, you know, to pay for something to show that she was truly, you know.
But this is not a trial, so we're getting testimony we don't necessarily, the court doesn't necessarily need. The court needs to know that she have a lawful eviction right now before her, and the court has confirmed that yes, she does. Do they have a meeting of the minds and are willing to vacate or set aside judge? No, they want to proceed. They do not have a meeting of the minds. So based on the statutory laws and laws that deal with possession and tenancy, Ms. Smith now has until June 5th to pay the rear.
Trying to pay.
Okay, so Ms. Smith, this was a lawful eviction. She did file a notice to quit on a state court administrative office form. She may, what it sounds like, have sent you a notice to quit that was not on a scale approved form. You don't necessarily have to use a scale approved form to initiate a notice to quit, but nonetheless, she did properly file this eviction and pay the filing costs. You were properly and duly.
The reason why the judge is entertaining this and clarifying particulars is so that the record is clean, so that the court reporter's records are clean, that there's resolution to this allegation by Ms. Smith that at some point in time there's an unlawful eviction. The record is now being clarified that this particular eviction that they're going forward with is lawful and has been conducted appropriately.
Served. So if there were an entity that was going to assist you, then that still could have happened. But nonetheless, that doesn't change where we are today. So unless you have any other matters for the court on this particular eviction, you are all set today. Okay?
All right, thank you.
Thank you. Okay, Mr. Asphalt is here. You're all set, Ms. Mendez. Thank you.
Okay, thank you, Your Honor.
Thank you. We're on the record in the matter.
Okay, so before the court moves on, we are going to just take ourselves a little break. We'll get back into this courtroom next time. Hopefully, this keeps the video shortened and you guys can watch it and have some enjoyment in your learning. One of the things we did learn was that right now we just took away the nugget that the form doesn't have to be on the judicial form. So Ms. Smith articulated and alleged that there was an improper eviction that took place earlier, maybe January's timeframe, that prevented her and hindered her from receiving governmental assistance or assistance in payment towards the arrears. And the judge has just clarified that whatever that was, you don't have to have it on the actual form, which actually you can put it in a legal pleading. There is a format that's on Word you can use, but you don't have to necessarily put it on judicial forms. Judicial forms are for convenience, and the best convenience, especially for layman's persons, because then you're making sure you're answering all the necessary questions, right? And you're putting the information that's necessary, but you could put it in paragraph form on a particular pleading paper. It doesn't have to be on a judicial form. So that's one of the things that was learned, that does not mean that it was not a legal eviction. But what I think more or less is what Ms. Smith was saying is that it wasn't filed, right? It was just a form without a case number, without it being filed. And so therefore it was not enforceable because it was just a document. And the entities that she was working with probably wanted something that was more enforceable and legal, so that, you know, they know that it's not something that someone just printed out and pretended to be legitimate. All right, so I'm Lyric Armstrong, and I'm your real estate agent and advocate. If you have any needs for real estate, you can contact me. If you are in this great nation, I have agents all across the nation that can help you. I do have agents in certain places, in certain countries outside of the United States. So you can still contact me. I might can refer someone to you there. But nonetheless, we are here. We're on YouTube doing YouTube things. We have done our housekeeping, right? So make sure that you did yours. We were liking, we subscribed, and we shared. All right. So we've wiped down the countertops, we've washed all the dishes, and we've swept the floor. All right. So we're good. The housekeeping is done. The day is done. We shall see and reconvene later. Lyric Armstrong, your real estate agent and advocate. Thank you and have a blessed one.